Hi, everyone. Judge Andrew Napolitano here for Judging Freedom. Today is Wednesday, December 7th, 2022. It's about 11:15 in the morning here on the East Coast of the United States. As I speak, the Supreme Court of the United States is hearing perhaps the most important case involving federalism in 20 or 30 years. Federalism, of course, is the concept that the states have certain areas of sovereignty with which the federal government cannot interfere. In this case, it has to do with redistricting, setting the boundaries for the legislative districts for the House of Representatives. So the legislature of the state of North Carolina redistricted North Carolina, changing the borders of the congressional districts. And people who were aggrieved by that sued, and the lawsuit made its way to the Supreme Court of North Carolina. And the Supreme Court of North Carolina invalidated what the legislature did, saying it was unfair. It was what we call gerrymandering. The districts were built in order to give Republicans more representation in the House of Representatives from North Carolina. It wasn't done in a neutral way. And so the more neutral districts were the ones that were used for the midterm elections of last month. Meanwhile, this challenge made its way to the Supreme Court of the United States, where it is today. The issue is, can the legislature of a state establish congressional districts free from review or interference by a state court? Now, normally everything that a state legislature does can be reviewed by a state court if there's a proper and appropriate challenge, just like everything the Congress does can be reviewed by a federal court if there's a proper or appropriate challenge. You can't just file a challenge saying, I think it's unconstitutional. If your ox was gored, if you were harmed, if you were uniquely harmed by what the Congress did, you can then challenge it. Same thing in the state legislatures, except in the state court systems, except there is a clause in the federal Constitution which says the state legislatures shall establish congressional districts. So if that clause is read literally, then the state court system cannot interfere with what the legislature did, because in the opinion of the state court system, it violates the state constitution. So that's what's before the court today. Now, here's why this is a big deal. Remember Bush versus Gore? That's the Supreme Court opinion in December of 2000, which put a stop to the endless recounts in Florida and declared that George W. Bush won the state of Florida and therefore was elected president of the United States of America because he received the majority of electoral votes, even though Al Gore received many more popular votes than George Bush did. We all remember that. But in that opinion, Bush versus Gore, there's language interpreting this same clause established by the legislature, which would allow the legislature to negate the will of the people in a presidential election and send its own electors to the Electoral College. So we don't know how the Supreme Court's going to rule. We don't know how far it will go. We don't know how much authority it's going to recognize that the state legislatures have. Small government people, libertarians like I am, believe that the statute, the clause should be read literally. The state legislature, which represents the people of the state, can establish the congressional districts, and the courts should have nothing to do with it, because this was one of Madison's checks on the federal government, that the states would influence who and how and from what districts representatives came from those states to the federal government, and the feds would have no say in this matter. Prediction, that's the way the Supreme Court's going to go, but it's a close call. The court is generally presumed to be 6-3 conservative, but not all conservatives are in favor of this, and not all conservative justices are in favor of it. Justice Gorsuch is an example, who believes in textualism. The words mean what they say. I'm sure will rule on the side of the states, because it just says state legislature. It doesn't say state legislature in accordance with the state constitution. It just says state legislature. So I'm speculating, which I probably shouldn't be doing based upon my understanding and experience in this area of the law, having practiced it, having ruled on it, having talked about it, having taught it, and having written about it. We'll see which way the court goes. But this could very well unleash state legislatures to have a lot more say in who your representatives in the House of Representatives are and from what part of the state they can come. Judge Napolitano. Well, more as we get it. Of course, we won't get an answer to this one until April. Judge Napolitano for Judging Freedom.